Chapter 1 Introduction. Forensic chemistry is defined as that branch of chemistry which deals with application of chemical principle in the solution of crimes. The value of the findings of a chemist in convicting the guilty as well as in clearing the innocent suspect has long been recognized not only in the criminal investigation and detection but also in court of law. Scope. Forensic chemistry is the science that deals with the study and application of chemical principles, is the solution of the problem that arises connections with the administration of justice. Practice of forensic chemistry. The work of a forensic chemist is divided into 4 stages, namely, number 1, collection or reception of the specimen. The proper collection, preservation, and transportation of specimens are essential in the investigation of a crime. Number 2, the actual examinations. Number 3, the communication of the result of the examination. Number 4, court appearance. Actual examination of specimen. The first step in the examination of the article is to scrutinize and careful and write down in the laboratory logbook or record book a complete description of the external appearance, including the manner in which it is secured and the particular of the sealing. Second step in the examination is to measure or weigh the object, and all measurements and weight should be entered in laboratory logbook or record book. The third step is the laboratory examination, which consists of chemical, physical, and confirmatory tests. Communication of result of the examination. The result of the examination conducted should be communicated with the requesting party in the form of written report, which must be include enumeration of fact on the specimens received of examination with detailed description of the packaging, sealing, and labeling date of receipt from whom it was received, the purpose of the examination, the finding, and conclusion. The last, court appearance. The written report in the forensic chemist is usually supplemented by testimonial evidence in a later date and the case is brought to court or the fiscal office. Role of forensic chemists in the scientific investigation. Number 1, conduct qualitative and quantitative determination of abuse drugs as well as volatile substances. Number 2, conduct chemical examination of explosive and or explosive ingredients. Number 3, conduct examination of paraffin cast and firearms to determine the presence of gunpowder nitrates. Number 4, conduct gunpowder examination on clothing for possible gunshot range. Number 5, conduct chemico-toxicological examination of human internal organs, gastric contents, blood, water or food sample, and other substances. Conduct examination of fake products in cases unfair trade competition. Number 7, conduct blood alcohol determination. Number 8, examines urine samples and other body fluids for the presence of abused drugs. Number 9, conducts researches related to the case being examined. Number 10, testify and give expert opinion in court. Give lecture on forensic chemistry and chemical toxicological to various school, university, police training and centers and investigating unit. Number 12, responds to queries of all investigating units and render expert opinion on matter related to the application of chemical principle for purpose of assisting investigators to develop investigative leads. The 6 golden rules in the practice of forensic chemistry. Go slowly, be thorough, be true. Number 3, take notes. Number 4, consult others. And number 5, use imagination. And number 6, avoid complicated theories. Equipment used in the forensics examination. Number 1, HPLC or high-powered liquid chromatography. This scientific equipment is used for the qualitative and quantitative determination of a volatile or non-volatile compound based on the chromatographic separation of its components. Number 2, ultraviolet spectrophotometer. It is used for the qualitative and quantitative analysis of organic compounds. Number 3, EMIT or enzyme multiple immunoassay technique. It is used for screening or abuse urine sample. Number 4, SEM or scanning electrons microscope. This scientific equipment is used for the physical identification of various questions and specimens. Number 5, FTIR, Fourier transform infrared spectroscopy, used for the identification of pure organic substances. It identifies organic substances, particularly abused drugs and explosive ingredients based on their characteristic functional group. Chapter 2, Preservation and Safekeeping of Evidence. The following are the guidelines in the proper preservation and safekeeping of evidence. Proper chain of custody shall always be observed. Number 2, all examined pieces of evidence, drugs, and other paraphernalia, explosives, firearms, and etc., shall be personal turned over by the examiner on case to the evidence custodians. Number 3, evidence shall be properly placed in suitable dry containers for proper preservation and shall be placed inside the concrete evidence room. Firearm evidence shall be kept in a separate evidence room specially designed for the purpose. In Chapter 3, Development of Scientific Crime Laboratory in the Philippines. February 14, 1822. Massacre occurred in Chicago. Then a group of public-minded individuals was responsible for the establishment of a scientific crime laboratory in that city, which today has marked its place in the historical annals or police science. March 31, 1876. Creation of Medicus Titulares by virtue of Royal Decree number 188 of Spain. For every province, a forensic physician was assigned to perform public sanitary duties and at the same time provide medico-legal aids to the administration of justice. December 5, 1884, Governor General Joaquin Haveler created a committee to study the mineral water of Luzon and appointed Anacleto del Rosario as a chemist. September 13, 1887, establishment of Laboratorio Municipal de Manila under the inspection of the Dirección General de Administración Civil and the control of other gobierno, the provincias. The function of the laboratory was to make analysis not only of food, water, and other from the standpoint of public health and legal medicine, but also specimen for clinical purposes. 1894, Laboratoria Medico-Legal was created under the dependency of judicial branch of the government and the laboratory functioning under the direction of physicians and assisted by a pharmacist chemist. 1895, Antonio Luna established a clinic clinical laboratory where some original works in chemistry were done. In 1899, the first scientific laboratory was established in a small building on the bank of Pasig River with LTRP Strong of the U.S. Army in charge. In 1901, actual scientific works began under the initiative of Dean C. Worcester by virtue of Act No. 156, approved by a civil commission. On July 1, 1901, the Bureau of Government Laboratories was created for the purpose of performing biological and chemical examination as well as for the production of vaccines and sera. March 11, 1915, the Department of Legal Medicine was created pursuant to the resolution of the Board of Regents. The department took charge of these courses of legal medicine and its branch in the courses of legal medicines and its branches, the College of Medicines and Law. On October 14, 1924, through the passage of Act No. 3043 by the Philippines legislature, the same Department of Legal Medicine became a branch of the Department of Justice and at the same time integral part of the university in the Philippines. On December 1, 1937, the Division of Investigation was created under Commonwealth Act No. 181 with 2 medico-legal officers and a chemist. September 1945, the National Bureau of Investigation or NBI was organized with the Division of Investigation as the nucleus. As a present, we have the Philippine National Police or PNP Crime Laboratory and the National Bureau of Investigation or NBI Laboratory. Crime Laboratory, also called Forensic Laboratory, facility where analyses are performed on evidence generated by crimes or sometimes civil infractions. Chapter 4 is Scientific Evidence. Evidence defined. Evidence is a proof of allegation. It is a means sanctioned by law of ascertaining in a judicial proceeding the truth respecting and matter of fact. Sec. Rule number 128, Revised Rules of Evidence. Evidence on collateral matter shall not be allowed except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Number 1, direct evidence is that which the sense of perceive. Any fact to which a witness testifies based on what he saw, heard, smelled, touched, or tasted is direct. B. Circumstantial evidence is a kind of evidence which seeks to establish a conclusion by inference from the fact proven. Illustrative case. Hearsay evidence is a statement made by a witnesses on the authority to another and not from his own personal knowledge or observation. Hearsay evidence is inadmissible except on the following: 1. Dying declaration. 2. Res gestae. 3. Declaration against interest. Number 3. Act or declaration about pedigree. Number 5. Family reputation or tradition regarding pedigree. Number 6. Common repetition. Number 7. Part of res gestae. Number 8. Entries in the course of business. Number 9. Entries official record. 10. Learned treatise. And 11. Testimony or disposition at a former proceeding. Form of scientific evidence: real or autoptic evidence. 2. Testimonial evidence. 3. Documentary evidence. And last, chapter 5, witnesses. Witnesses defines as a witness court in a court may be ordinary or except witnesses. Under the law, an ordinary witnesses must have the following qualification. He must have the organ and power to perceive. He must have no organ and power perceive. Perceiving can make known his perception to others. He does not fall in any of the exception provided for by law 1, 2, 3 rules of court. Probative value of expert testimony. Whether courts are not bound by the testimony is an except depends upon the nature of the subject or inquiry. Qualification of an expert witness: A. Degree of learning of the witnesses. B. The basis and logic of his conclusions. And C. The other proof of case.